Good afternoon. Today is Tuesday, January 7th, 2020. This is the first hearing of the month and of the year for the City of Tempe hearing officer. I'm going to read something real quick into the record this afternoon, and then we'll jump into our very short agenda. The City of Tempe hearing officer is authorized by Arizona Revised Statutes and the City of Tempe's Zoning and Development Code. The hearing officer has the duty to carry out both the provisions and the intent of the Zoning and Development Code and the City of Tempe Code. The hearing officer is granted the authority through Zoning and Development Code Section 6-310 to conduct public hearings to decide upon the abatement of code violations occurring on properties within the City of Tempe. These violations include, but aren't limited to, deteriorated landscaping, inoperable vehicles, deteriorated structures, storage of junk or refuse, or deteriorated swimming pools. Abatement actions are brought before the hearing officer by the city's Code Compliance Division, typically after numerous attempts at contacting the property owner to obtain voluntary compliance with the city code. The hearing officer may issue an order directing the owner, occupant, rental agent, property manager, or other responsible person to abate a code violation or authorize the city to abate the condition giving rise to the violation. The cost of such abatement is the responsibility of the owner of the property where the violation occurred and may be collected as an assessment against the property found to be in violation. We have two items on our agenda this afternoon. The first is a set of minutes, and the second is a single property abatement. Any property owner who's aggrieved by a decision of the hearing officer may file an appeal within 14 calendar days after the hearing officer makes a decision. As such, the deadline for appealing any decision rendered today is 3 p.m. on January 21st. Appeals are heard by the Board of Adjustment, after which they may also be appealed to the Superior Court. A property owner has 14 days to either file an appeal or bring the property into code compliance. If neither of these things happen by this date, the property will be abated by the city. My name's Vanessa McDonald, and I'm the hearing officer, and this afternoon I'm joined by Shelby Meyer and Drew Yoakum of Development Services. First item on the agenda is a set of minutes from the hearing December 17th, 2019. I had a chance to review those minutes in the packet I was given from staff, and I did just want to make a brief statement. That hearing was very lengthy. It was an hour and a half long on a single case. Due to some technical issues, disability issue by the applicant. I think some of the hearing was disjointed and hard to follow. I think Ms. Myers did a good job representing what took place. But I just want to make a note that the minutes that we provide are not intended to be a verbatim account of what takes place at a hearing. They're intended to be a summary and provide the tone of what was said at a hearing. And so even though the minutes may look a little bit short or truncated, they accurately reflect what took place at that hearing without being redundant and going back and forth to the many issues that were brought up that evening. So that being said, I'm going to go ahead and approve the minutes for December 17th, 2019. The next item on our agenda is a request for approval to abate public nuisance items at the Maroney property located at 1952 East Concordia Drive. The applicant is City of Tempe Code Compliance. Mr. Glab.
Good evening. Michael Glab, Residential Code Inspector for the City of Tempe. I'm here tonight in reference to this property at 1952 East Concordia Drive. In August of 2019, my office received a complaint related to junk and debris on the property, including the backyard. I inspected the property and observed what appeared to be junk and debris present in the backyard landscape. I then mailed a notice to the property owner. In September of 2019, I followed up and saw little to no change, and so then I mailed a second notice to the property owner. I then followed up later in the month and then observed little to no change, and so I posted a notice to the front of the structure. In October of 2019, I followed up at the property and saw little to no change, so I then issued a citation to the property owner. And then in November of 2019, I returned, observed little to no change, and requested bids to submit for the abatement process. Then in December of 2019, I submitted the application for property abatement, as again another inspection in December of 2019 saw little to no change in the backyard. At this moment in time, I've had no contact from the resident or the complainant beyond the initial complaint in August of 2019. Nobody else has reached out to my office to discuss the case with me. And as of today, I believe there's photographs showing the state of the backyard landscape.
Yes, I do have them. So when you say little to no change, you actually mean no change, right?
Well, one item I did note was that on the shed roof, I believe a bicycle part had been removed. So I think there was a wheel or handlebars to a bicycle, but
Okay.
they appear to have been removed.
But essentially, no change. It's not like he or she is trying to,
Correct.
make any sort of progress. So, yeah, I have the photographs from this morning, which will be part of the record, and, it indicates that there are serious issues on this property. I don't see any members of the public here this afternoon, so I don't believe I need to make a call to the public. I agree with your assessment of the property, that it's in need of abatement, and I am granting your 180-day request for the abatement.
Thank you.
You're welcome. That's the only item on our agenda this afternoon. Does staff have any announcements? 21st. We do have a meeting on the 21st. Okay, our next hearing will be January 21st, 2020. Thank you, we're adjourned.